Welcome. Good to see everybody face to face. It's been a little bit of time since we've all connected, so it's good to see all your faces here today. We've got a little bit of agenda in front of us. We'll try to run through this per usual. You know how that works. So we'll go quickly and efficiently through the items we have listed. All right. Let me start with the roll call. Ben Grove. Matt Reddish.
Here.
Patrick Green.
Here.
And if you folks would just move your mics towards you, make sure it's off of mute. I should have probably hit all that button before we got started. Here we go. We've got Ben Grove, Matt Reddish, Patrick Green, Dan McGrew.
Here.
Christy Halbert.
Here.
All right, great. Thank you. All right, we have quorum. Let me read the notice of meeting into the record. Notice of the September 20th, 2021 meeting of the Athletic Commission, including date, time, and location, has been noticed on the website since June 16th, 2020. Additionally, this month's agenda has been posted on the website since September 13th, 2021. All right, for the agenda, are there any questions, edits, or revisions on the agenda here? If not, we'll entertain a motion to approve the agenda as written. Do we have such a motion?
I'll make that motion.
All right. Thank you, Dr. Halbert. We got a motion from Christy Halbert to approve the agenda. Do we have a second?
I second.
Thank you, Dan McGrew. Roll call vote. Or I guess we're so used to doing the necessity of the remote meeting, we don't have to do that today, do we? So all in favor, say aye.
Aye.
All right. Thank you very much. That's approved. Moving on to the June minutes. Right there in front of your iPad, you'll have all the documents you need as we work our way through the agenda. And plus, you've seen that as well over the weekend. Do you have any edits or any comments on the June minutes? Okay, we'll entertain a motion then to accept the June minutes. Do we have such a motion?
I make a motion to accept the June minutes.
All right, Mr. McGrew, do we have a second?
A second.
All right, got one from Patrick Wren. For all in favor, say aye.
Aye.
All right, thank you very much. That's approved. On to the budget then. All right, we've completed one fiscal year, and then we're in the start of a second. At the last meeting, we went over the reserves and the fiscal year's expenses and revenues through March. As a result, we'll primarily focus on the last 4 months of record. That'll be April through June, and then July of the next fiscal year. At the last meeting, I noted that the increase in admin costbacks and technology compared to year prior, which were both specifically related to our share of the expenses coming from the core vendor, resulting from upgrades that were benefiting all of regulatory boards. We did some upgrades to public search and some other functionality inside of core, and that was our share of that. We'll look at the primarily. We'll look at salary and benefits under Edison totals, and then also field enforcement line item under the expenses. So you're looking at about that second row under Edison expenses where it says salary benefits. And if you go a little further down, you'll see near the end, third from the end, field enforcement. That's primarily where most of our costs are coming from, as you know, and it's quite costly to staff an event with all the positions that they have to post. So that's where we're headed right now. We are keeping a P&L to track those expenses to make sure that we're doing the best we can on the admin side to capture whatever those expenses are coming from and where we can mitigate that. We have hired some new part-time inspectors as well, and we expect to have some more of them in the field. So that'll help us with travel. Should also help us with the hourly wage and the benefits since we won't be paying those benefits. So, but let's move on to the next one. We're carrying over a deficit of $27,000 from that fiscal year, and then bringing that over. We're looking at, and then the following month we've got a $1,400 deficit as well. So we're tracking, as you know, until we have a bigger event, or even some events that do better than that $500 gate fee with sales. If we get ticket sales to to the point that we can sort of capture some of that travel and inspections costs, I think we can tip the scales. But until then, as you know, that's not atypical for us to track in the red. We just want to make sure we don't go too deep in the red where we can't get back. And so we were in last year, but we've had two. If we get in again this year, then we'll have a self-sufficiency hearing, which is not atypical. But as long as we can explain that and point to that using our P&Ls and showing them where those costs are coming from and how we're mitigating that, I think we shouldn't have any problems. So until we get that big event and can somehow stabilize with our inspections cost, I think we'll probably continue to track in that vicinity. Are there any questions as to that? I know that's not a surprise to any of you sitting on the board. Good news is that we're carrying over. We're only in the red about 8,000, which if that was our personal checking account, we probably wouldn't be too crazy about that. But given a board this size, you're looking at that's 2 or 3 events really is what that is in the red in inspections cost. So we're keeping it pretty close. If there's any other questions, that was just for informational purposes. That doesn't have to be approved. So we can move on to the next line item. I'll give you a moment to sort of reflect and pause. But if there's no questions, we'll move on. Okay, I think we're ready for the one championship portion of our agenda. We had an administrator from One Championship reach out to us requesting a waiver from the commission to conduct their events per Rule 145.3.012. I'll let Pam sort of outline the criteria for that waiver request and read that rule to you, and then we'll, of course, field any questions after that.
Good afternoon, everyone. As you all are likely familiar, the rules provide both for boxing and MMA and kickboxing. Under the initial provision of the rule, it specifically modify or waive a provision if there's a request in cases of undue hardship, impracticability, or necessity, or as was mentioned, number 2, for purposes of allowing a bout to be sanctioned by a recognized association, council, or organization. Key under our rule, it says the provisions of this chapter shall apply to professional kickboxing and mixed martial arts. It says the same thing for boxing. My understanding from reviewing both emails and documents that were provided by One Championship is that they are requesting a waiver. Just so the commission knows, to my understanding, you all have never granted a waiver. The waiver would be allowed under the circumstances that I mentioned. But before or if you intend to consider a waiver, I would mention a couple of things. One Championship has provided their rules, but has not provided specific information about which provision they would be wanting a waiver for. They've just provided their rules in the entirety. As such, I did not go line by line through our rules compared to their rules, but I do have some things for you to consider. For instance, their rules and medical information for high-risk athletes, our statute is 35. At age 35, as you all know, we require additional testing. Their rules are at age 40. So that is, to me, a significant difference, and one of which that is in our statute, not in our rule. So we don't have any control over that unless there was a change in the law. There are some other differences to consider. One related to grounding issues. They allow, and I'll just summarize and not go rule by rule, but their rules allow for stomping of a grounded opponent. We do not. They allow for kneeing of a grounded opponent, and we do not. And then, of course, I've covered the high-risk athletes. There's also some differences in the weight classes. And I can go through those if you like, but it's just a difference in the weights. As you go further down from heavyweight to lightweight, there are some differences between our rules and theirs. So obviously, it's within the board's discretion to grant a waiver of any provisions of our rules. I would recommend that we refer back to One Championship and ask them specifically what discuss it further.
Steve, could you touch your speaker buttons?
Oh, I
Yes,
think I
ma'am.
was pushing the wrong one. I was curious, on page 3, middle of the page, one of the bullet points under time limits, 1 night, 4-man tournament bouts. Do their combatants participate in more than one contest per calendar day?
That would be, this is the packet that they've submitted, so I do not know if they're in attendance today. We did supply them.
Oh. We can take those list of questions back to them because they'll have to present those provisions that they're going to want waived. So I'll make a note of that here as well. And then your questions that you come up with throughout the next several weeks ahead before our next meeting, just forward those to me as you look over their package, and then we can address each of those plus the ones they're requesting to make sure we've got all of those differences mapped.
Well, I personally can't understand how we could grant a blind waiver to someone, that is requesting that. I mean, that they would have to have a lot more information, exactly what they want waived in that case.
We know if they're actually trying to put on an event here, or are they just fishing for a venue that might waive rules for them?
The latter. Yeah, there's no specifics yet. They're looking for some venues to come to, and to your point, Commissioner McGrew, that's why we were asking them for each waiver, each provision. So your instincts are right on spot with the rest of us as well, because we couldn't get in the business of just doing blind waivers for groups coming in. Because then what's the point of our rules? So we do need to go item by item, and they need to let us know which of those rules that they wished waived. Now, of course, if they butt up against statute, then there's nothing we can do for them, and then we'll of course inform the commission in that regard as well.
I know there's some federal statutes in regards to boxing, and did you mention some of the rules have to do with boxing, or is this only MMA and kickboxing?
This is for MMA and kickboxing. I was just mentioning that just because the applicability part of the rule applies to both boxing or MMA and kickboxing. It's written the same in the rule, regardless of the type of event. But this is more kickboxing MMA style, is my understanding.
Do you know if any other states have given them any kind of waiver?
I haven't done that research yet, so I haven't heard back from them in that regard.
That may be one thing we want to ask them.
I'll compile that, and we'll
I know
put that
like
out there.
ABC has a set of rules they promulgate every year, and I know they get a little testy when people try to go outside that. So I'm just curious if anybody had yet.
I'll definitely look out and see where they're conducting their events. But while you're doing your leisurely reading and you've got that packet out, at some other venture, if you just outline all of those, send those to me, and then I'll just compile that list and we'll go down the list and make sure we get a reply from them on each of those. All right. And then it'll either be the next meeting or the one shortly thereafter, depending on their response. Okay. Unless there's any other questions, we can move on to the next one. Looks like it's the legal report. That's back to Pam.
For this afternoon's legal report, before we get started, cases number 1 and 2 were going to be before you on a summary suspension, but the promoter has agreed to the summary suspension. So I have printed copies because it was after all the materials were sent to you all. So we will not be having a summary suspension hearing today due to the fact that the promoter has signed the agreed order for summary suspension. I will need the board chair as well as all of you to review the document, but I will need the board chair to sign the document. It's already, like I said, been executed by the promoter and myself. So here's the original. The top one is the original that I'll need back, and then these are the copies. Yes. And I apologize on the front end for the color of the paper. That is the way it was scanned back into me from the promoter. So while my paralegal and I did our best to try to figure out a way to get it to print on regular paper, this is the best that we could come up with because it came back to me in a pink color. I will generally summarize complaints number 1 and 2 on the legal report, which are the ones related to this summary suspension. But I'll give you a minute just to review the document first. And what I would like to do is briefly give a summary of what the respondent has agreed to, which will also apply to numbers 1 and 2 on the legal report. The summary suspension is in regard to Tracy Crutcher Kennemore, license number 4862, who resides in Chattanooga, Tennessee. Her license is current as a promoter. Based on information provided to the program, 2 complaints were opened, 2021-06-353 and 2021-06-460. Based on information provided, Ms. Kennemore was provided notice on September 14th, 2021 of the Commission's intent to proceed with a summary suspension hearing. She was provided both the copies of both complaints and additional information regarding fraudulent blood work results, which was received by the program. Specifically, the commission was provided, when you received your agenda and other documents for this meeting, you were provided a spreadsheet that had various fighters listed, their license numbers, the event dates, the manager, the region, the test date claimed, and the test date was confirmed. As you will notice from the spreadsheet, the dates simply do not match up. This information was provided by the promoter. The documents were provided by the promoter. The promoter, in various emails to me, accepted responsibility for this and agreed to the summary suspension. The summary suspension is under Tennessee Code Section 45320, which allows the commission, if the public health and safety welfare is affected, you can proceed with summary suspension with or without notice. We provided proper notice to the promoter. She has agreed to the summary suspension pending a hearing. This is where we would now move to the legal report just in way of summary. The summaries for both of the complaints are contained in the legal report. My recommendation, now that the respondent has agreed to the summary suspension, is for you to authorize me to go forward with a formal hearing for revocation of the respondent's license under both of these complaints. I do want to also let the commission know and pass out for your review. Ms. Kennemore this morning provided a response. She is not disagreeing with the summary suspension because she's already signed it. But this morning she did submit a response that I did write back to her, and I did inform her that I would let the commission know that she provided a response. While understanding that she has signed the summary suspension, she did want you all to have this response. It is not my intent to read her response into the record. However, in your review of her response, she is obviously proposing a resolution, basically stating that she wants to ensure this never happens again. She will not accept any medical documents in the future, and her position is the combatants should send in their medicals directly to the program for review. And just so the commission knows, obviously, when we get to a hearing, if this board approves my recommendation for a hearing on revocation, obviously at that time, Ms. Kennemore can present any proof that she has with regard to the extent she wants this commission to consider something else other than revocation.
Got a question about the process for submitting paperwork based on Ms. Kennemore's letter. How is paperwork typically submitted to the board?
They can submit paper, but that's irregular. We discourage that just because it slows the process down. If they have old forms, then that just dramatically creates hurdles for everybody. Typically online, and in this case, it was all online, and but it's not atypical for promoters to create accounts for their fighters and then load up their paperwork. We do have an email from Miss Crutcher Kennemore stating that she had access to their accounts, and so we at least know that that she had access. Now, no one was physically there other than Miss Crutcher Kennemore, I presume, when that happened. But nonetheless, she had access, and that's not atypical for promoters to do that.
Further, just so the commission knows procedurally, here's what will happen from here. The board chair has signed the summary suspension. That will be in effect until we have a hearing. The hearing will be before the board, and then at that point, we'll circle back to the legal report here in just a minute to get authorization for either revocation or however the board wants me to proceed. But the summary suspension will be in effect as of today. Then Ms. Kennemore will be notified of that. She will then, at any hearing that we have, obviously have an opportunity to present her proof, any witnesses, anything she wants to present going forward. As it relates to the legal report, if we can now revert back to that, on numbers 1 and 2, that obviously is related to the summary suspension. And as I stated earlier, my recommendation is authorization for a formal hearing for revocation of the respondent's license. Related to those two, I would need board approval to move forward with that. And then we also still need to take up number 3 on the legal report.
Unless there's some further discussion on it, let me read those two into the record then, and then we'll just take a vote in that regard. Number 1 is case number 2021063531, and case number 2, which is related, is 2021064601. And you've heard the council's recommendation. Do we have any motion or any comments in regard? She's signed the summary suspension, so it'll be suspended until we have that. And what the council is recommending is authorizing a formal and a hearing to take up a revocation. That's the will of the commission. We'll just need a motion in that regard. Do we have such a motion?
I'll make the motion.
All right. Thank you, Dr. Halbert. We got a motion from Christy Halbert. Do we have a second?
I'll second that.
We have a second from Mr. Grove. All in favor, please say aye.
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 Any opposed? All right. Let the record show that the council's recommendation goes forward. Number 3.
As it relates to number 3, I will read the summary, but as you note from the legal report, it's marked for discussion. This is case number 2021-064741. This individual was first licensed in 2015. The license is currently expired and has been expired for more than 2 years. This complaint was opened administratively after this respondent provided an email to the legal division attempting to accept responsibility for the 3 of the combatants for whom the promoter submitted fraudulent blood work in the above complaints. The email was received by legal after the promoter received a copy of the first complaint. This respondent is listed as the trainer for 5 of the combatants and further listed as the manager for 2 of the combatants, all of which are subject to fraudulent blood work submissions. I marked this for discussion because we already have someone accepting responsibility via summary suspension. However, I believe it should be concern to this commission that we have another individual who was licensed by the department who's trying to accept responsibility. Based on that, that is why I marked it for discussion. I believe that a civil penalty is appropriate. I will leave it to the will of the commission to decide what that should be. I think that my recommendation would be it should be at least $250, if not more. We have at least 3 combatants that this particular individual is trying to take responsibility for. But I would say the minimum would be $250 that you should consider, and obviously you can consider more than that.
Is that total or per combatant?
It can be per combatant.
And this would be paid by the promoter?
No, this would be paid by this respondent. This complaint is related to this particular respondent who is also listed as a trainer and manager.
License had expired for...
His license has been expired since 2017, so he would need to reapply for a license.
We this strategically, the idea is to have some disciplinary action on record as well. Should he decide that he wanted to get further licensure here, that could be drawn into that consideration, because they have to answer in the character questions: have they ever been suspended or have they been under disciplinary action with other commissions? And so we can flag it, but it seems, given the situation, that it rises to the occasion, that it requires a little bit more consideration, and we want to make sure that we have done that and taken that under account.
Now, his license had expired back in 2017, and he is listed as the trainer of 3 or 5 combatants. Have they participated in any events since 2017?
Several of those were debuts, and I don't have it in front of me, but I don't believe so. They were relatively new fighters.
But the individual, he knew that his license had expired.
This individual, it was a second. He was a second. That's all he's been inside Tennessee. Right. So the folks that they brought to us with the fraudulent blood work, those are relatively new fighters. So we don't have a long period of time that we can say that this has been going on up until recent.
What was the fraud that was committed on the documents?
So the issue is we received, and I think it's in your packet of materials, as I understand it, we received blood test results from LabCorp. The issue is when we circled back to request a test, the dates do not match up. So, for example, you may have someone with a test date claimed of July 16th, 2021. When the program attempted to confirm that, there's no record of any test on that date. Further, if you look at the LabCorp documents that were submitted, one thing I also found, and I'm obviously not an expert on LabCorp, but if you look towards the bottom of the document,
it's on document number 6 under summary suspension. You have the spreadsheet before you, and then Pam is referencing the LabCorp reports there. Sorry, Pam, go ahead.
And as you're looking through the documents from LabCorp, you'll see towards the bottom where it gives like patient details. Some of the information is not filled in, which it would. So that presents an issue. Then, in addition to that, the test dates simply do not match up.
When we do our file reviews, how it came about was we see a lot of these LabCorp reports. You can imagine, MMA and boxers, and we saw some of the patterns weren't consistent, but only with this promotions team. We stopped, looked at it, called, requested test, And if you look at that spreadsheet, some of them they don't even have a record of. So there's reports claiming there was blood work done and there was no record.
Yeah, I mean that's borderline theft of services, isn't it? Borderline.
We're just limited to our scope, obviously, within the commission. But, of course, we want to exercise the full authority of the commission in response to that.
Yeah, I just sort of meant that fairly severe.
And that would be related to item number 3 on the legal report, not the respondent.
Yes.
Two separate issues. We have 1 and 2, which is the respondent that's agreed to the summary suspension, which you've already voted on. Number 3 is a separate individual who's only accepted responsibility for 3 of the combatants.
Yes, ma'am.
Are there any other comments in that regard?
Well, this individual who was the trainer for these 5 combatants is not licensed, but he will receive if we make him pay a fine, he will have to reapply for a license, but his license probably would not be accepted until he pays the fine, correct?
So procedurally, how this would work is obviously I can't make anyone pay the fine. We would submit a document to him that we refer to as a consent order, which is basically a settlement document. If the commission was so inclined to do a $750 civil penalty, that would be contained in the consent order. If he signs that and pays, then the case is closed and he will be reported on the disciplinary action report. His license, being that it is already expired and expired more than 2 years, even if it wasn't for this complaint, he would still have to apply for another license because his license has been expired more than 2 years. But given this complaint, he will have discipline on the record. If he applies, then the program in reviewing his application will then likely consult with legal, and we will decide whether he needs to come before the board to be considered for any future license. That would procedurally how it would work. Let me go ahead and take this a step further. Obviously, the consent order is a settlement document. If he does not sign and send in the civil penalty, then we would be having a hearing similar but different to Ms. Kennemore. It would be before you all, a hearing to determine what should happen to this respondent. It could be a civil penalty. At the time of the hearing, you are not limited to the $700 civil penalty. If he does not sign this settlement, you have a range of options at the time of a hearing for this particular respondent. Like Ms. Kennemore would have the opportunity to present witnesses, evidence on his behalf. He can hire an attorney if he so chooses. So that's kind of the procedure depending on whether or not he signs the consent order or not.
Has he also participated in boxing in the state of Tennessee without a license since his expired, or did he not participate in these events?
Trainer isn't required to be licensed. Manager would be, a matchmaker certainly, but no, he wasn't.
He was not a second.
He was a second back, and that expired in 2017. But from then forward, there was no licensure or requirement for such based on his participation.
So at the events in question, he did not work as a second?
Not to my knowledge. Mm-hmm. There was no complaint, at least, that we're aware of. Right now, we had discussion about $250 per 3 charges, totaling $750. Is there any further discussion on that as it's been fielded?
I have one other question. So submitting paperwork, I would assume, is a typical role of a manager. So he may have been acting in capacity as a manager without a license, correct?
It's manager is not clearly as defined as some other industries. Like for example, in Cosmo and Barber, you have statutory sort of requirements as a manager. Athletic commission's a little bit different in that regard. It's really kind of like even actually second is more clearly defined than manager. Manager is more of a one of representation, but not clearly sort of extrapolated out of the statute. So that one's a little bit more difficult to pin. Now managers can second, and so we have some that will do that, paid sort of the upcharge too. But it's really one of almost it's almost a business license almost in some regard. One that's it's elective more than it is sort of necessarily required in all instances. So some folks choose to represent themselves in business sort of transactions, and so technically they are a manager, but since it's not statutorily identified or extrapolated from our law, then we can't really hold them to requiring them to get that license.
Well, I think that $250 is probably more reasonable for this individual. For this, it was a second. He trains these guys or helps train them, 5 of them. He's more apt to pay the $250 and get his license rather than he would $250 per person. I can't see he'd probably pay that. No, he wouldn't. So I think $250 would probably be more reasonable.
Like you can make that in the form of a motion, and we can have further discussion about. Would you like to make a motion that we have a $250 penalty and then authorized for formal hearing should he not agree to that fine?
Correct. I make a motion to that effect.
All right. Thank you, sir. We have a motion. Do we have further discussion? All right. We can entertain a second then. Do we have a second in that regard? Mr. Wren, looks like you have, I can tell you want to tell us something.
You guys have run me around the tree this time. All right. We got 3 situations where we're going to find them $250 each on these situations that we're dealing with.
Right now, the motion's $250 total right now.
$250 total.
Yes, sir.
Okay, but a minute ago it was $250 each. Okay, and see, that's where I'm getting confused. Here's the way I see it, if I may. You got a guy who decided he'd take on a job that he didn't keep his license current in. It was 2 years expired. And we're going to fine him $250 for 3 combatants, correct? Or $250 for the whole ball of wax. The guy's license went out the window 2 years ago, and he had to know it. I got old boxing licenses from 30 years ago. I still carry around in my wallet. I can't help but think that this human being knew what he was doing. I think we ought to entertain the $750 for the 3, $250 each, instead of $250 for everybody. And I think something ought to be done to talk to him about keeping his license current instead of waiting 2 years and coming back and causing us a bunch of trouble.
In this particular instance, he wasn't required to be licensed. But because trainer isn't a license necessarily. So in that regard, I think hence the latitude. But to your point, yeah, that's correct. He hasn't been licensed for 3 years, so it's been a little while. But it wasn't required in this situation.
Right.
I'd like to just echo my colleague's point that it seems what we have is an issue of people serving as representation for boxers and yet choosing not to be licensed. And so I guess I am wondering, do we have any protection against that moving forward? The person in the office that receives the paperwork, do they only receive paperwork from licensed individuals, whether that's the boxer themselves or a manager or promoter?
I'll let Glenn speak in a moment, but to your point, as the commission knows, we mainly are notified about issues through the complaint process. So if someone is unlicensed, if the program were to find that out, they would open an administrative complaint, or we would rely on someone to notify us of unlicensed activity. And I'll let Glenn speak to your other question about what happens when the paperwork is received by the program.
But what is the cost of a manager's license? Do we know offhand?
Yeah.
$100.
It functions really more like almost like a seconds license. I mean, except for they can represent them, but it's not, the statute isn't as firm as far as the criteria of what that representation would look like in a practical sense. And I appreciate Pam sort of putting the guardrails back up, because obviously these 3 complaints came administratively. If we're aware of any unlicensed activity or anything that's happening that isn't within our rules or statute, we'll open that up. We don't wait on somebody to report that. But typically, if we're not aware of it, we can't regulate something we don't know about. So if something comes in and we see it, then we'll report it. But other than that, we just have to wait on the public or tips from the public in that regard.
Well, I'm sure my colleagues feel the same way. I think the office did a fantastic job looking into this and helping protect future combatants. I know that we probably all have stories about various unscrupulous individuals who they'll take shortcuts when it comes to athlete health. And so I just want to say kudos to the office staff that caught this and looked into it.
Thank you, Doctor. All right, we do have one motion on the table that we'll have to dispatch with. Do we have, so right now, as it stands, the current motion on the table is 250 total. Do we have a second? All right, if there's
I'll make the motion to do 250 per combatant.
So it looks like we don't have a second, so the first one will fail. So now we have a new motion, which is 250 per combatant for a total of 750. Do we have a second in that regard?
I'll second.
We have a second from Mr. Reddish.
Just a little discussion.
Yes, sir. Open for discussion.
That particular individual, he's not going to pay $250 per person. He's not going to do it. He's not going to pay it.
Yeah,
that's not going to keep him from working as a trainer for these guys at their gym or wherever they go or whatever. And he's more likely to still come back again. But I'm pretty sure he may not even been able to afford his license. That's why he didn't get his license renewed. I'm not saying for sure, but I'm saying, so if he's not going to be able to pay $100 to get his license.
The license isn't the problem. It's the fraud that he committed for his fighters. Like, they could have blood diseases or anything else because he changed their paperwork, and the other combatants were also put at risk because of it. So due to that, if he can't pay the $750, I'd rather him not be able to get a license.
I'd say his ability to get a license in the state again after this is us being pretty generous to him.
Those are all good comments. It's difficult when you have a range and then you have the special considerations, because you there's so much that the table to consider. Is there, unless there's an amendment to the that motion, then we'll have to take a vote. Is your motion stand?
Yes, sir.
Okay. And we have a second then. All in, yes, sir, please.
Second.
All right. Well, we have 1 second with Mr. Reddish, and we have an original motion with Mr. Grove. All in favor, please say aye.
Aye.
Any opposed? All right. Thank you. The record will reflect then. That motion will pass by majority then. Thank you for your comments, and I appreciate your passion for the sport too. I can tell each one of you care about these our public and our fighters, and so I appreciate your commitment in that regard. All right, it looks like we're ready for a rule amendment then. And again, this is Pam's venue, so it's going to be all her meeting, it looks like.
Thank you, Glenn. As the commission is aware, from the June 14th, 2021 minutes, I brought before you at that time a discussion about some amendments to the statute that will go into effect October 1, 2021. At that time, I discussed with you all that we would need to do a rule amendment related to the 90-day time frame for physicals, which is changed by statute. So now the rule will need to catch up with that, because the current rule states 30 days to submit physical, eye exam, and blood work, but now that will change to 90. So while you have the red line for the rulemaking hearing, and you notice that there are additional provisions that are being changed, you all have already approved the other changes. So the only change or addition to this rule packet is related to licensing under 145-01-.03. That will be changed from 30 to 90 days. The rest of the packet you all had already approved. What I'm hoping is that with your blessing today, we can move this through the process and hopefully, in consideration of time, have a rulemaking hearing in December if I can get the packet approved in time and the proper notices.
And if you recall, that's our unified rules and failure to appear rules package that we already had in the pipeline. This will be connected with that and travel together. And this is just a cleanup, basically, to put us in line with the public chapter that the statute was passed earlier. Thank you, Pam. I appreciate you walking through all that.
So I will need a motion, just because we have added to the rules packet that you had already approved, moving from 30 days to 90 days in the medical section of the licensing. So I will need a motion and a second just to approve that, so that I can travel with that forward.
I'll make that motion.
Thank you, Dr. Halbert. We have a motion from Christy Halbert. Do we have a second?
A second.
We have a second from Dan McGrew. All in favor, please say aye.
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 Any opposed? All right, that's passed, and we'll get those traveling together, and we're going to try to do that rulemaking hearing on in our December meeting, and then once that's done, that's our side of the business will be complete, and then it just has to work its way through the pipeline. All right, that's all I've got on the agenda. Do we have any new business? All right. Hearing none, I think we can entertain a motion to adjourn. Do we have such a motion?
I would like to say first,
Yes, please.
that I attended a pro show that was held at the fairgrounds in Nashville, and I'd like to commend the people, the commission that worked that particular show. They, as always, carried themselves in a professional and manner, and saw that the show was started on time, and everything seemed to work out pretty smoothly. So it was a great group of people working that particular show.
Thank you, Chairman. I appreciate that, and I imagine that they don't get to listen to all of our meetings, but I'll definitely pass that along to them. So thank you for that. And I do appreciate all your attendance. Those of you that can and are able and make that effort when possible. Thank you for your your service in that regard.
And with that, I'll make a motion to adjourn.
Thank you, sir. We got a motion from Chairman McGrew. Do we have a second?
I'll second.
We got a second from Mr. Reddish. All in favor?
Aye.
I,
All right. We are adjourned.